We'll move to the next subject, and the next subject is unnecessary arrests to settle scores or with corruption motive or other vested interests, addition of non-bailable sections to prevent the granting of bails. Now, this will be covered by Dr. B.K. Upadhya. Dr. B.K. Upadhya is a 1989 batch serving officer from the Maharashtra. At present, he is a Commandant General Home Guards there. Earlier, he has headed the prison department. He has headed the traffic branch of from the police headquarters. He has been a CP Nagpur as well as CP Sholapur. One thing which is interesting, I must mention that he has a MA and PhD in Sanskrit literature and Sanskrit phonetics, which is a very rare kind of a distinction. He has written 4 books, and the topic around is mind management. So with these words, I would now request Dr. Upadhya to start his conversation, please.
Good morning to everybody. First, I extend my gratitude to Dr. Ish Kumar sir and IPF for giving me an opportunity to share my views and experiences about unnecessary arrests. I just want to start with a very famous couplet by Ghalib. खुदा की मोहब्बत में फना कौन करेगा, खुदा की मोहब्बत में फना कौन करेगा, सब बंदे नेक हो तो गुनाह कौन करेगा. After all, offenses are bound to take place in the society, but all the accused persons are not the criminals. Therefore, whom to arrest and whom not to arrest is a very important legal and human aspect. This matter needs to be debated and inculcated in the minds of all the police officers who are effecting arrest. Arrest by police has been a very burning topic forever, but the focus which it is attacking today is a welcome step in the criminal justice system and the society at large. It is a very progressive state by IPF to organize this symposium, and I hope that it will go a long way in highlighting the different dimensions of arrest. Here I want to mention that the apex court, our Supreme Court, has observed on so many occasions about arrest, and all those observations have crystallized in the oft-quoted maxim bail and not jail. And it has found its strongest expression in the famous Arnesh Kumar judgment in 2014, as discussed by so many speakers. But still, it is a sorry state of affair that despite all the observations of the apex court, the relevant case laws, the amendment in the CRPC, the arrests are being done by police officers in the most blatant way and violative of the instructions of the apex court and the procedure established by law. Sir, in this case, I want to quote 2 High Court judgments, and I think every police officer should remember these 2 judgments, their contents, their consequences. Sir, the recent sentencing of the concerned police officials for violating the instructions given in the Arnesh Kumar judgment by Delhi and Telangana High Courts is just the tip of the iceberg. The Delhi High Court sentenced a police officer to 1 day imprisonment as he had arrested a man in defiance of the guidelines laid by the Supreme Court in Arnesh Kumar versus State of Bihar. The case against the man was of criminal breach of trust, having a maximum sentence of 3 years. And hence the notice of appearance under CRPC 41A was needed to be served, which was not done by the police officer. And in that case, as per the order of the court, Section 41A was violated. This is the famous Delhi High Court judgment, Rakesh Kumar versus Vijayanta Arya DCP and others. Sir, the recent case which has attracted lots of attention and discussion is the Telangana High Court judgment, sir. In a similar case, sir, on 6 June 2022, in Jaka Vinod Kumar Reddy versus Srinivas and others, the Telangana High Court has convicted 4 police officers, including one IS officer, for violating the norms prescribed by the Supreme Court in the Arnesh Kumar while dealing with the marital dispute cases and also getting a lookout notice issued against the accused by suppressing the material fact. The court observed that the contemners had violated the direction of the court for issuing notice of appearance under Section 41 CRPC within 2 weeks from the date of the institution of the case as per the direction of the apex court in Arnesh Kumar case. Violations which are likely to infringe upon the faith of public in the administration of justice and the court system must be punished to prevent repetitions of such behavior and the adverse impact on public faith. Sir, these 2 judgments of the High Court are very important, and I, as a police officer, welcome these judgments. We have discussed these judgments in our crime conferences. We have discussed these judgments on our WhatsApp groups, and we are telling our police officers who are working in the field that it is the high time that we should learn the lessons from these courts. I know so many petitions which are still pending in High Court, so many High Courts in the state where such matters have been raised up. And I am concerned that in coming future days, more and more police officers will be punished by the court. And it is a hard time for us to learn such lessons. Sir, while working as a police officer in the field, I have come across the cases where the police officers pounce upon the accused for arrest the moment FIR is registered and the offense is cognizable. Whether to arrest or not is based upon the discretion of the concerned police officer, and this discretion is used in most of the cases for ulterior motive, like for corruption, for settling scores. Sir, one new trend has started in police department. They want to follow the Arnesh Kumar guidelines, but when they find that we can't arrest this man, we have to give the notice under CRPC 41A. Now they are adding serious non-value sections just to escape the provisions of Arnesh Kumar judgment. And the sections which are being liberally added to escape this provision are 420, because 420 section is a section which can be stretched to any extent. 467, 468, so many sections of IT Act. These sections are being added so that the accused may not be able to get bail, and we have not to comply with the provisions of Section 41A. I have come across so many cases where the courts have intervened and the court deleted those sections, and so many police officers have been asked to go through departmental inquiry also. It is a good thing. Sir, while working as the ADG prisons of Maharashtra, I had an opportunity to visit prisons and interact with the inmates of the prisons. As a police officer, we don't know the condition of the prisons in a very positive way. As a police officer, most of the time we think that persons should be inside jail, those who have committed crime. But when we work as a prison official, we know that the situation is different and everybody is not a criminal. In any prison, when we survey, we find that the criminals whom we call criminals in traditional way, who are habituals or who are gangsters or who belong to gangs, the number in any prison sir, is not more than 5%. About 90 to 95% persons who are in the prison, they are not criminals. They have gone to prison either this way or that way. Again, as shown by Rampal sir and other speakers, how the cases which are not of serious nature and where the punishment is up to 7 years, such cases constitute the bulk of the cases which are registered and where persons are arrested. The serious offenses are not more than 10-15%, but still the number of arrests where punishment is up to 7 years or where the offenses are not very serious, the number of and percentage of arrest is very high. Sir, I perused lots of such relevant papers.
Dr. Upadhya, 2 more minutes.
Sir, and at the police station also, and some very interested conclusions have come out. As earlier pointed out, I also found that 40% of arrests are unnecessary and they can be avoided. In so many cases, the officer has not mentioned the reasons of the arrest. Mandatory provisions of CRPC 41A were not complied with. And the most surprising thing is that the judicial magistrates also did not apply their mind. They just mechanically remanded the accused to the jail. Therefore, in my opinion, discretion is the most nebulous thing. Discretion should be removed and no arrest should be made where the punishment is up to 7 years. When I was working as police commissioner Nagpur, police commissioner Solapur, I have given the instruction only habitual offenders should be arrested and supervisory officers have to play a very important role in it. And as pointed out by Ramchandran sir, for internal reform, we do not need anybody's instruction. We don't need anybody's blessing. We don't need anybody's instructions. We can do it. And if senior officers decide, they can do it. I conclude my speech by one Urdu couplet. कुछ ऐसे भी मंजर हैं तारीख के पन्नों में, लम्हों ने खता की और सदियों ने सजा पाई. Hours, weeks and months spent by such persons in the jail destroy the decades of their concern. Thank you, sir.
Thank you, Dr. Upadhya, for making a series of relevant points. I think the 3 important points what he made is he quoted the 2 judgments from Delhi and Telangana High Court where police officers have been punished for not following the procedures laid down under 41A as well as the Ramesh Kumar judgment. Alarm bells must ring among the police officers on these 2 judgments. He also spoke about a dangerous trend that to avoid following Ramesh Kumar judgment, police officers have started adding non-bailable serious sections so that they can get away. And the worst culprit is, third point is 90 to 95% of criminals in the prisons are not habitual offenders. They are not professional criminals. They land up there because of some circumstances. And the police discretion must be done away with. That's the 4th point he made. I think number of series of relevant points. Thank you, Dr. Upadhya.